decision will be reasoned. They will communicate it to you. They can take whatever steps they want with the state government. But if you are aggrieved by, either of you is aggrieved by it, then you can take remedy in accordance with law.
A fair proposition, Milord.
Not sure.
Because I am not going to decide that. It's a matter which is exclusively within the domain of the district council. Again, the state had no authority to decide it unilaterally without reference to. So we are correcting that. Till such time, both the amendment and the parent statute will remain in abeyance.
My Lord, what happened here, my Lord? It appears as a apparent error, my Lord, while publication in the Gazette. And that is why the district council has written to the state government that there is an error in the printing in the Gazette, and please rectify it. And that was rectified, my Lord.
It was rectified.
It was rectified, my Lord.
And then it was amended.
My Lord, thereafter what happened, my Lord? The dispensation changed in the district council, my Lord. They issue an executive order recalling the amendment, my Lord.
They issue an executive order,
my Lord.
and they pass it on to the state.
No, my Lord. But I'll just place the facts, my Lord. Two or three documents, my Lord. My Lord, here.
So very well, we will stay that order of the Executive Council,
My Lord.
and any steps taken pursuant to that.
My Lord.
All right?
My Lord.
We will require the District Council, the Executive Committee, to give an opportunity of hearing to both of you, and then take a reasoned decision which it will communicate to the state, and it will communicate to you, against which you have the doors open once again. That unilateral act is what we want to.
My Lord, it is not a unilateral act, my Lord.
It was done with reference to you.
My Lord, I'll just place two or three documents, my Lord.
Yes.
My Lord, page 49 is a letter, my Lord, from the district council.
Just a second. 49
My Lord.
of your petition.
Yes, my Lord.
Yes.
My Lord, this is a letter from Secretary District Council to the state government, my Lord. It says, my Lord, with reference to the subject mentioned above, I am to inform you that after comparing the original bill as passed by the council in session with the original publication of the said act in the official gazette, it was found that there are discrepancies appearing in the schedule 2 of the act. Example, Nongklao instead of Nongklauruni and Sankur Ride Milim appearing twice in the said schedule at serial number 1 and 2. After that, my Lord.
We are only concerned with only serial number 1.
My Lord.
We are not concerned with serial number 42.
My Lord. Thereafter, my Lord, the state government issues a gazette notification, my Lord, page 50, my Lord. Page 50 is the gazette notification rectifying that mistake, my Lord.
Page?
Page 50. Next page.
Yes.
So, my Lord, once this was done, everything was in place, my Lord.
This is, which one? This is number 14.
14, my Lord.
The first part of 14.
First part of 14, my Lord.
Yes.
So, once this was done, my Lord, everything was in place. The bill as passed by the district council remains in the gazette, my Lord. Thereafter, my Lord, page 62, my Lord, will see.
82.
62, my Lord.
62. Yes.
My Lord, the executive committee on the executive side of the district council, my Lord, passes a resolution, my Lord.
And who was it who had, this is the legislative secretariat of the district council. Earlier legislative secretariat.
Earlier it was a legislative action, my Lord. Now they come on the executive side, my Lord. Page 62 says, my Lord, the executive committee, Khasigal district council, after consideration of the corrigenda published in the Gazette of Meghalaya so-and-so, pertaining to Khasigal so-and-so, has decided to recall the same with immediate effect due to procedural lapses.
Very well. And then the state has taken action.
Yes, please.
Where is that?
State taking an action.
Additional affidavit. Your additional. It's the additional affidavit filed by the petitioner at page 9, my lords.
Page 9 of the additional affidavit, my Lord. filed on 5th August.
Page 9.
Page 9, my lord. And it should be.
One 138 to 150. Yes. Coriander
Is hereby withdrawn,
entire corrigendum.
my lord.
And what is page 62?
Page 62 is the resolution of the district council on executive side, my lord.
Page 62 pertains to the entirety of the corrigendum.
My lord.
Coriander.
My lord.
Yes. Yes, Mr. Quinta, what is your stand? What we want to do is that, mistake or no mistake, we will stay both the withdrawal,
Corrigendum dated February 13, 2018.
17.
the withdrawal and the original also. And
Lordship,
we
here
will permit, yes, tell us what your stand
the
is.
issue here is not the entire act of 2007.
Only that part.
The
limited part. But your resolution at page 62 pertains to the entire corrigenda. It's not limited to 11 part 1. Because if you see at page 51 has number of corrections.
Yes, Lordship.
And it's only 11 part 1 which is subject matter of dispute over here.
Yes, Lordship.
Now your page 62 is omnibus. It has no reasons. It is omnibus. So therefore we, in respect of this at least, in respect of everything, you should reconsider it. And particularly we will say that if you want to maintain, if you want to take a, whether you, which way, we will say whichever way you take a decision in respect of 11 part 1,
14 part 1.
14 part 1.
14 part 1, 14 part 1 at page 52,
51.
51.
51.
51. At page, appearing exactly at page 52, 14 part 1.
My lord.
Appearing at page 51, my lords.
Appearing at page 51 is
14 part 1.
14 part 1. 14 part 1. Then before that you'll have to give them, both of them a hearing and take a reasoned decision.
It will be item 14, page 51.
Only part 1 of item 14 pertaining to non-claw, ringy and non-claw. Nothing to do with Sanku Red Million.
Accepted.
And we'll confine the withdrawal at page 62 also to this aspect of the matter. Nothing else.
My lords.
My lord, will restore our position
Restore your position.
till the decision is taken, my lord.
We'll set aside the the legislative decision, and we'll also say that no precipitous action in terms of the original act should be taken till such time a decision is taken by the district council in such regard.
My lords. That would be balanced, my lords. That would protect our interest also.
Otherwise, if the act remains, but we are saying no precipitous action. No precipitous action will be nothing which is irreversible. because that would then be stealing a march. I am not deciding it.
My lord, what will happen, my lord? This is a legislative action, my lord. The members of district council in session, my lord, decide the matter. I am not very clear on how they'll give an opportunity of hearing in the session of the district council, my lord.
The legislative side, my
We
lord,
will take a call from the executive committee and will present it before the legislature of the district council.
because it's a factual issue, my lord, so they could probably hear both the parties and then place it before the floor.
Mr. Dr. Mozika, even legislative business is sent to a select committee. When a bill is proposed, a bill or any part of the bill is produced before a select committee. That select committee then makes an in-depth inquiry. In course of that inquiry, it's possible to call for representations. We'll provide for that.
My lord.
Not only one aspect, my lord. Annexure 9 and Annexure 10, both, there are two resolutions of the district council, my lord. Page 62 as well as page 70.
Page
70, 70.
62 and 70. Just hear the order and correct us, both of you or all of you. The matter pertains to an act by the name of the Khasi Hills Autonomous District bracket appointment and succession of CM, Deputy CM, electors and Rangbashnong of William CMship bracket closed Act 2007, which was published in the Official Gazette on April 9, 2008. Full stop. There is no dispute that the act that was published was somewhat at variance with the bill that had been forwarded by the district council to the state government. Full stop. As a consequence, by a letter dated May 12, 2017, the Legislative Secretariat of the Khasi Hills Autonomous District Council drew the attention of the state government to the perceived mistakes in the statute and required such mistakes to be corrected. Full stop. Paragraph. The relevant letter referred to two perceived mistakes. Full stop. Colon. That in Schedule 11 of the Act, non-claw had been included instead of non-claw ringi. And that in the same schedule, open quote, Sankur, Rise William, close quote, was appearing twice, full stop. Paragraph. The present matter is confined to the non-claw and non-claw ringi aspect, and nothing herein will affect any other matter referred to in the relevant letter. Full stop. Paragraph. Following the receipt of such letter from the Legislative Secretariat of the Khasi Hills Autonomous District Council, the state government caused a set of corrigenda to be issued, to be published in the official gazette on July 11, 2017. The corrigenda has 14 items, and the present matter pertains to the first part of the 14th item. Full stop. Paragraph. The 14th item in the Corrigenda published on July 11, 2017 provides as follows, colon, next line, open quote, 14 full stop, in schedule dash II, serial number, capital S, small I, full stop, then capital N, small o, full stop, number 5, insert the word within quote ringi, close quote, after the word non-cloud, within quote, and delete the words Sankur, within quote, Sankur Rice Million, within quote, from San to Million quote, appearing below the words, within quote, Archival Jait, comma, Right Sang Shnong, full stop, close quote. Paragraph again, comma, the present matter is confined only to the aspect of, within quote, ringi and non-claw, and has nothing to do with the repetition or otherwise of, within quote, Sankur Rice Million, close quote, full stop, close quote. Paragraph. After the publication of the aforesaid corrigenda, comma, the Executive Committee of the District Council, comma, by its resolution of December 20, 2017, resolved that the corrigenda published this is a corrigenda published on, we said July 11, it should be July 13. Corrigenda published in the official gazette on July 13 ought to be recalled. Full stop. The Executive Committee of the relevant District Council, comma, accordingly, comma, forwarded the matter to the state government along with a further resolution of January 9, 2018, by which it was resolved to denotify the entirety of the corrigenda published on July 13, 2017. Paragraph. Upon receipt of copies of such resolutions, the state caused a further publication to be made in the Official Gazette on February 13, 2018, by which the entirety of the corrigenda to the Act of 2007 that had been published on July 13, 2007
70.
was withdrawn. Paragraph. The grievance of the petitioner is that the original bill that was submitted by the legislative wing of the relevant district council, which was the appropriate authority to look into the matter, indicated Nongshor Ringi and upon the word Ringi within quote being mistakenly left out in the statute in Schedule 11, it was the legislative wing of the district council that required the correction to be made so that the statute adhered to the suggestion that was forwarded in such regard by the district council. Full stop. Paragraph. According to the petitioner, since this was a matter of enacting a law, it was the legislative wing of the district council which was the appropriate authority, and the executive committee could not have overridden the legislative wing to require the state to withdraw the corrigenda that had been published at the suggestion of the legislative wing. Full stop. Paragraph. The district council has produced its records. Full stop. It is submitted on behalf of the district council that the original bill that was forwarded to the state indicated Nongshor Ringi in Schedule 11, and it was, upon realizing the mistake in the act that was passed, that the corrigenda in such regard was requested. Full stop. The district council, however, makes no submission as to how the executive committee of the council came to advise or instruct or recommend to the state government, contrary to what had been indicated by its legislative wing. Full stop. There appears to be some substance in the petitioner's submission in such regard that when the matter pertained to the enactment of a statute and a proposed bill had been forwarded by the legislative wing of the district council, as to whether the resultant act was in accordance with the proposed bill or not, was a matter which, ordinarily would be within the exclusive domain of the legislative wing of the district council. Full stop. However, it cannot also be said that the executive committee of a district council would have no authority to rectify a mistake, though, ideally, there ought to have been some communication between the executive committee of the district council and the legislative wing of the same district council before the executive committee's decisions were forwarded to the state. Full stop. The private respondent is also represented and claims that it was an obvious mistake in the original suggested bill. All these bills are B capital. To indicate non-claw ringi in the relevant schedule, and the reference should always have been to non-claw and not confined to non-claw ringi. Full stop. Such contention is seriously disputed by the petitioner. Paragraph. What is evident is that a particular bill was forwarded by the legislative wing of the relevant district council to the state for enacting a law on terms thereof, in terms thereof, but there were certain mistakes in the statute which the legislative wing of the relevant district council sought to correct. Full stop. In such a scenario, the executive committee of the district council could not have jumped into the fray and undone what the legislative wing of the same district council had caused to be done. Full stop. Paragraph. However, without going into the merits of the matter and the propriety of either non-claw or non-claw ringi figuring in Schedule 11 to the said Act of 2007, the resolutions of the Executive Committee of the Khasi Hills Autonomous District Council of December 20, 2017 and January 9, 2018 are set aside insofar as they relate to the reference in Schedule 11 to the Act of 2007 to non-claw within court or non-claw ringi within court. Full stop. As a consequence, the withdrawal of the corrigenda by the publication made in the Official Gazette on February 13, 2018 is also set aside. Full stop. That would result in the corrigenda that was published on July 13, 2017 to be revived. Full stop. However, in view of the further directions issued hereafter, the petitioner herein will not be entitled to steal a march or obtain any irreversible benefit or adopt any irreversible measure that cannot be undone. Full stop. Such direction is necessary in view of the order proposed to be made herein. Full stop. Since it appears that the legislative and executive wings of the same autonomous district council may have been unaware of the stance taken or may have been at loggerheads in such regard, what does the sentence go about? Since may have been at loggerheads, and may not have consulted each other, at least as to the reference in the statute being non-claw or non-claw ringi, the petitioner should not take any precipitous step that may be difficult to be undone. Full stop. WP number 57 of 2021 is disposed of by directing the Khasi Hills Autonomous District Council to take a reasoned decision in the matter whether the reference in Schedule 11 to the relevant act has to be to non-claw ringi or only to non-claw. Such decision will be taken within 4 weeks from date upon first hearing both the petitioner herein and the respondent number 6 or their authorized representatives. Full stop. In case it is the legislative wing which is deemed to be the appropriate authority to take the call, comma, a select committee of legislators as may be formed by the Legislative Council will hear both the petitioners and the respondent number 6 or their authorized representatives before taking a final decision in the matter as to whether Schedule 11 to the said statute should refer only to non-claw or to non-claw ringi. Full stop. The decision paragraph. The decision in such regard ought to be reasoned, and such reason should be furnished to both the petitioner and the respondent number 6. Full stop. It is hoped that paragraph the decision is taken by the appropriate body of the Khasi Hills Autonomous District Council within a period of 14 days, and such reasoned decision is communicated to both the petitioner and the respondent number 6 within 7 days of the decision being taken. Full stop. Nothing in this paragraph, nothing in this order will prevent either the petitioner or the respondent number 6 from questioning the relevant order passed by the district council on any available ground, on any ground available. Full stop. Paragraph, there will be no order as to cause.
Well, it's just two issues, Mills, I thought I should point out. Well, it's one is, Mills, the main stakeholder in this entire process is the CMO Milliam, respondent number 5, who's the proposer of the bill. And this entire dispute pertains to, Mills, his dorbar, where it should be non-claw ringi or non-claw. So I thought, Mills...
Very good. Oh. In course of the hearing to be afforded, pursuant to the directions issued herein, comma, the same of William or a duly authorized representative of that same should also be heard.
The other issue is, your lordships have restored the corrigenda. Well, it's by virtue of that corrigenda, your lordships would have to clarify that whatever falls out of the select committee, the corrigenda will be subject to that. Well, it's that I thought.
Paragraph. The validity of the corrigenda published on July 13, 2017 will be subject to the decision to be taken by the appropriate authority within the district council as provided for herein.
Obliged.
Lordship, I have a small, just a correction. Instead of Schedule 11, it should be Roman 11. Otherwise,
Schedule 2.
instead of, it should be schedule Roman 2.
Schedule 2. Wherever I've said 11, make it Schedule 2.
Roman 2.
Roman 2. II, capital II.
Lordship, I couldn't understand that point. The matter will be heard by the district council in the legislative wing or by the executive committee.
Because that is for you to decide.
Okay.
That is for you to decide. We have indicated ideally it should be in the, but that is for, again, according to your laws, according to your custom, we don't want to impose that. It would be erroneous to impose that. Though initially we've indicated it should be that. But again, if a wrong body hears it, they will have a right. Whoever is aggrieved will have a right.
Another suggestion, Your Lordship.
Yes.
14 days is too short. It should be at least 4 weeks.
Very well, 4 weeks instead of 14 days.
And instead of 7 days, it should be at least 14 days.
Which one?
Thereafter,
Yes.
Communication 14 days.
Communication 14 days. So the decision 4 weeks and communication fortnight.
much obliged and good.
Thank you.
Good day.
But only one aspect
Yes.
which I did not. My lord, in district council there are 3 separate branches, my lord, as in state assembly or state government, my lord. There is a legislative branch where all 30 members of the district council in session, my lord, they pass any legislation, my lord. So after a legislation is passed, it is sent to the governor for assent only, my lord. And after that, it is published in the official gazette. Here, what has happened, my lord, the bill was passed by the district council in session, my lord. It was sent for the governor assent and publication in the gazette. In my humble submission, at that stage, governor either gives his assent or returns the bill, my lord. He cannot make any changes to the bill that has been passed by the
We
district.
have not provided for the state government to do anything. We've only said the district council will decide. Which wing of the district council decides, ultimately we will have to decide later.
Right.
Because I'm not conclusively deciding that either. So if according to you, executive committee decides, you'll be entitled to challenge the order if you're agreed by it.
My lord.
In either case, in this case, Manoj, I don't think the state really interfered. It was more of a
Yes,
mistake which was compounded.
exactly. Thank you.
Right.
Offline.
This was a headache for me personally. Because it was hanging fire for a long time.
Long time.
Thank you.
Offline.